Good morning. Do we have Mr. Franz?
Good morning.
Good morning.
Okay, good morning. I'm Judge John K. Stargell, court in and for the 6th District Court of Appeal is in session in a Zoom hearing. Joining me here today is Judge Keith White and Associate Judge Brian Lambert. First of all, want to apologize somewhat for the late notice and having to change this to a Zoom format. One of our spouses was ill this weekend and tested positive for COVID, and we figured with the holidays coming up, everybody would probably prefer not to have that risk going around your families and around the courthouse. I'm sure all of our friends over at the Orange County Courthouse also appreciate that. Also want to give a shout out to our staff who yesterday was a holiday and some of them had to scramble to get a hold of everyone's offices and to get this set up. And some of them are actually veterans. And but thank you to all of our veterans out there, especially those who had to work on our behalf yesterday. Okay. We have two cases. We'll go to a different Zoom channel for the second one, but our first one this morning is the case 2023-3207, Brittany Hines versus Bashida Wilson. We have Mr. Franz on behalf of Ms. Hines and Mr. Bird on behalf of Ms. Wilson. Mr. Franz, your client is the appellant. You'll be going first. Would you like to reserve some time for rebuttal?
Respectfully, 5 minutes for rebuttal, Your Honor.
5 minutes for rebuttal. Okay. Well, you'll see in the screen there your clock. I will let you know if I think you're going a lot over that, so that it's cutting into your time. But unless anyone else has anything else or any other questions, then you're recognized to begin.
May it please the court, Kevin Franz on behalf of Brittany Hines. Hines was denied a fair trial based on striking of all of her experts, denying leave to identify a Fabry defendant, improper accident report privilege evidence, and improper closings. Individually and cumulatively, the effect of these was to deny a fair trial, and we request the court reverse and remand for a new trial. As to the striking of the experts, the trial court erred as a matter of law in striking the experts under Binger. Binger, of course, applies where you have a witness who was never disclosed, but is disclosed at the last minute or maybe an exhibit that prejudices the other party. In this case, the experts were all timely disclosed. It's not an issue on appeal. There were no new opinions. There is no Binger prejudice. In fact, there is no Florida case where a timely disclosed expert was stricken under Binger simply for failure to allegedly provide sufficient financial bias information. So as a matter of law, and this is not under abuse of discretion, this is under de novo, as a matter of law, the court erred. Even if this court looks to other reasons which the court didn't give, which would be under 1.380 for striking the witness, the trial court abuses discretion. And I think the main case that this court should focus on is State Farm versus Nob Hill, which is 328 Southern 3rd, 1, Florida 4th DCA 2021. So in that case, the trial court struck the defendant's expert based on a discovery violation. The plaintiff sought the amount of money that the experts were paid by the defense and the insurance company and the Elkins lists. There were 5 months of extensions and unverified answers that were sent. They eventually did show the amount that was paid, but that didn't match with some of the documents that were sent, that were provided in terms of the money paid to the experts. The trial court found deliberate violations of court orders and inaccurate financial information and struck the expert. The 4th DCA reversed, found it was an abuse of discretion, and it announced some critical legal tenets that are important here. Striking an expert under 1.380 is, quote, a drastic remedy which should only be utilized under the most compelling circumstances. And that's because the right to call witnesses is one of the most important due process rights of a party. Indeed, absent evidence of a party's willful failure to comply or extensive prejudice to the opposition, exclusion of this testimony is an abuse of discretion. And also importantly, a litigant, such as Ms. Hines here, should not be punished for the fault of the part of its counsel by such a severe sanction as striking a witness for noncompliance. Now, in that Nob Hill case, the appellate court found there was no showing of willful failure to comply or contumacious disregard of the court's authority. The defendant there attempted to comply, but there was no absolute refusal. In this case, the record is clear that we attempted to comply at every turn, including second amended verified answers. The trial court judge specifically did not find any willful non-compliance by the attorney in this case for Ms. Hines. The drastic remedy in this case of striking every single one of defendant's expert witnesses, the punishment simply did not fit the crime here. It violated the defendant's due process rights to call witnesses. And even though there may have been a discrepancy about the finances, that's something that's the subject of cross-examination, not called for in striking all of the three witnesses. And the unreasonableness really is shown by the judge's rationale. And the judge said, and I'm paraphrasing, the prejudice here is not just financial bias. The information requested would have provided Mr. Byrd the ability to locate transcripts of the experts so that a bank of resources could be created, and perhaps not for this case, but for future cases, and perhaps not only for Mr. Byrd, but for other lawyers. That is not the purpose of discovery in Florida law. The purpose of discovery is to discover relevant information for the issues at trial. Moreover, we provided Elkins lists, which included the case names, the case numbers, the dates of the deposition testimony, the dates of the trial testimony, in some cases the courts, and in some cases the opposing counsel. All of this that's only what's required under the law, and that's what we produce. So the contention that Mr. Byrd would not be able to discover depositions is simply not supported by everything that was produced. Mr. Byrd then, in closing argument, and this is another basis for our motion for new trial, took advantage of the exclusion of these witnesses and said in closing, and this went to the concept of future medical expenses, which two of the three witnesses were going to be talking about. He said, quote, so we need to talk about the future medical expenses, but there's been a lot of different testimony presented to you with regard to future medical expenses, which, by the way, the defense never disputed. We objected and moved for a mistrial because, sort of under black letter law, it's improper to exclude evidence and then seek an advantage before the jury because the evidence wasn't presented or the defense had no favorable testimony to provide on the issue. And that's exactly what occurred in this case. And it was an abuse of discretion not to grant a mistrial. So initially, because we were deprived of due process, a new trial was required based on striking of all the experts. The next issue I want to get into is the accident report privilege. The timeline is important in this. So Hines moved in limine to exclude any references to statements made to or by the investigating officer. Then Wilson filed video deposition designations of Hines and her passenger Reynolds, which included objections to accident report privilege. Then the trial court granted the defendant's motion in limine. So at that point in time, all evidence of statements made to or by investigating officers, as a matter of ruling in this case, were prohibited. Then at trial, Wilson played the depositions of Hines, at which point counsel was shocked to find out that this information that was excluded by an order in limine was still in the record and moved for a mistrial. The trial court immediately recognized that the testimony given by Ms. Hines was accident report privilege and should not have come in. But the judge did not grant a mistrial because he found that Hines waived the privilege. That was an abuse of discretion because Hines, number one, objected during the depositions to accident report privilege. And there was a court order in place specifically excluding this evidence. So Hines, of course, was under the reasonable belief that this evidence would be excluded from evidence and not come in, and that Wilson would adhere to that order. There was no need to object to the order in limine after the designations were made. There's no need to object further because the order in limine was in place. Under Florida law, when a judge issues a clear order in limine, there is no need to then raise the issue again. The evidence that came in related to an issue that was hotly litigated, which was liability. The plaintiff argued that there were police officers directing traffic that everyone should have seen. Hines, on the other hand, testified that she didn't see any police officers, didn't see any lit wands, any cones, any markers, anything. But the testimony that came in was after the accident when Hines and Reynolds were speaking to investigating officers, and the officer pointed out that the other police officers directing traffic were indeed directing traffic. Why is this so important? Because the evidence suggests that Hines disobeyed police officers. In fact, she was cited for that. Now, that did not come into evidence, but she was cited for a violation of a traffic law. And we rely on the case Vantren versus Ryder Truck, 890 Southern 2nd, 421, Florida 1st DCA 2004. And I quote, generally, questions or allusions which suggest that a driver has or has not been charged with a traffic violation are considered sufficiently prejudicial to require a new trial. And that's exactly what occurred in this case. So for that reason, additionally, a new trial is required. Your Honor, I would, unless Your Honors have any questions about the Fabre issue, I have covered the issue in closing and everything else. I'm happy to answer any questions the court has. Without that, I would sit until rebuttal.
Judge White, Judge Lambert, questions? Okay, you have right at 10 minutes remaining then. Mr. Bird, you're recognized.
Good morning, Your Honors. Jeffrey Bird for the appellee. I was also trial counsel for Ms. Vashti Wilson. The issue before this court, framed by the appellant, is 4 different points, all of which relate to a very common analysis, which is the abuse of discretion by not 1, but 2 judges, Judge Tom Young and then his successor, Judge Chad Alvaro. It's a very heavy burden that the appellant had both post-trial and also here in these proceedings. 2 well-experienced judges have disagreed with the arguments advanced by appellant, as appellee also disagrees. Their arguments were not only disagreed with by appellee and 2 separate trial judges, but they were largely rejected. This is a case that has been thoroughly briefed as to all 4 issues. I stand on that written answer brief filed by myself on behalf of Ms. Wilson. I'm certainly happy to entertain any questions that the panel may have as to those 4 distinctly different issues. One issue that I didn't brief, but I did see that the the appellant referenced the case in the reply brief, is a case of, I'm going to terribly mispronounce it, Lagu versus Union Carbide Corporation. They cited that case in the reply brief at page 11. I reviewed that case, and that case actually proves the appellee's points on appeal, which in this case, as it relates to this notion that the court committed error or abused its discretion in failing to allow vague, non-party law enforcement agencies to be placed on the verdict form, that case actually cites the positions followed by the trial judges. which relates to there's a burden on Ms. Hines, her counsel, to have presented evidence, some sort of proffer with respect to actual negligence of third parties. Counsel has argued today and also throughout his brief that she didn't see lights, but at no time was there evidence presented that the officers failed to have their lights on or that they acted in any negligent manner. Indeed, her own passenger's testimony was that at the time of impact, he saw law enforcement officers there controlling the intersection. So her failure to see is not negligence by them, but is actually proof of her own negligence, which this jury concluded that she alone was negligent and apportioned no negligence to my client, Ms. Wilson. So the Lagu case actually supports the position that there was a burden placed upon appellant's counsel at trial to present not only arguments, but evidence that would show what entity was negligent, what did they do wrong, how did they act in a manner that no other law enforcement agency controlling an intersection would have acted. And there was no such proffer at time of trial because frankly, there was no evidence obtained as to those points in the discovery process by appellant's counsel. So unless the panel has any further questions, I'll stand on the written brief that's been presented in this manner.
Mr. Byrd, could you briefly address what Mr. Franz brought up on the issue of the judge ruling about the need for a bank of cases or future cases, and the fact that it seemed to possibly go outside the realm of just discovery for this case?
I would regard that in the same manner that I think the panel is equally familiar with dicta and appellate decisions. The judge gave a very long dispositive verbal or oral ruling to support his findings of fact. That was just one of many factors. It was an accurate statement, but that wasn't what the court's decision was based upon. The court's decision in this case was based upon 6 months worth of dilatory delays and violations of multiple, not just one, but multiple court orders following lengthy dispositive hearings that consumed much of the trial court's time. So I know that they wanted to make that a feature as to show why they believe that that was an abuse of discretion. I would regard that as just simply colloquy or dicta by the trial judge explaining of the many reasons why he ultimately came to strike the defense's experts. I will also note that it is interesting in this case that there was an earlier hearing on a motion to strike defense's experts held in March, which that judge at that time said he was not going to strike. He said not yet. He gave the defense yet one more chance to correct their shortcomings and failures with respect to the expert discovery. But as was clear from the hearing held the week before trial in May, the court was not satisfied that they had done anything actually responsive to that which was ordered. They've given a long list of all of the non-responsive things that they provided, but what was noticeably absent, and the court was very cognizant of this, were the actual things that were ordered to be produced. And none of those things were produced. And even on appeal, they still argue all of the non-responsive things that they did produce, like, for example, an Elkins list. But an Elkins list is a list prepared by an expert. It is not in any way responsive to the actual interrogatories that the court with specificity ordered the defendants and the real party in interest in this case, which is Progressive. That was noted multiple times by the trial court that the real party here is not Ms. Hines, although she's the named party. The real party in interest is Progressive. And they were woefully deficient and also failed to even support with any affidavits why they couldn't produce the information that the Florida Supreme Court 26 years earlier in the case of Allstate versus Bosher said could be obtained with a mere push of an icon or a button on a computer screen.
So is your position that had that been the reason, the only reason granted, that it would be proper for the judge to have made that ruling, or simply that since it's dicta, it doesn't matter because he gave other bases?
I would argue the latter, Judge. I would certainly agree if that were the only reason that the judge had advanced. Well, first off, that's not even the reason that I had advanced on behalf of my client. But if that were the only reason that the judge had advanced, then perhaps that would fall in the realm of an abuse. But this is a case where, and it really is important for purposes of context, because while I did reference many other issues that are not germane to the exact issues on appeal, I understand. I wanted this court to understand the magnitude of discovery problems that were being caused by the defense of this case, ranging on a wide variety of topics where there was complete failure to comply with court orders with respect to those matters as well. This is a case where they were given chance after chance after chance after chance, and literally spanning 6 months, never got around to producing that which was actually ordered to be produced, and instead produced other non-responsive materials that they contend, well, that's good enough. That should have been sufficient enough. But that's not what the court's order was, and the court was very clear as to why their non-responsive production failed to comply with that which had been ordered by the court on multiple prior occasions. Unless the panel has any further questions, again, I'll stand on my written brief.
Either of my colleagues, anything?
No questions.
Okay, Mr. Franz, we'll put back up your 10 minutes, your remaining time there, and you're recognized.
Thank you, Your Honor. So Mr. Byrd said this is an abuse of discretion, but that's not, this should be reviewed de novo. Mr. Byrd never suggested that Binger was appropriate for this court to strike the witnesses. The question is Binger appropriate? And the answer is clearly no, as there's no single Florida case that's ever allowed for striking expert witnesses based on what the other party claims is insufficient financial bias. And let's talk about another thing, which is what was produced. Nowhere in the answer brief or what Your Honors have heard today.
Counsel, let me follow up on that just quickly. So is it your position then if in this case, a defense counsel said, we're just not going to produce the financial information because Binger doesn't require it, have a nice day, see you around, that the judge can't then strike the witnesses because you're not disclosing the financial bias information that would certainly be good fodder for a plaintiff to present to a jury?
In that case, the judge could strike the witnesses under Rule 1.380, but the judge would have to find willfulness in failure to do so. Basically saying, no, I don't care what you're saying. We're not going to make any attempts. We don't care what your orders say. We're going to do nothing.
Okay, so he didn't make that express finding here, but certainly the tenor of what was going on is, and you were not the trial counsel, I assume, right?
Correct.
Okay, he for lack of a better term, an Ocalian term, he had a tummy full of dealing with non-responsive information coming from the trial counsel, and eventually it got over the edge and he exercised his discretion. And you're saying because he didn't say, oh, by the way, I find this to be willful, that it should result in a new trial on this issue?
Yes, because the due process right to calling witnesses is so sacrosanct. The necessary level to strike all three expert witnesses, the punishment has to fit the crime. You have to find willfulness. That's under the Nob Hill case. And it's also really important to point out to this court that nowhere in the answer brief or today did Mr. Byrd explain what was missing. And that's because nothing is missing. And here's what was provided: fee schedules, all CVs, the summaries of all their opinions, again, all Elkins lists, which totally allowed Mr. Byrd to get whatever treasure trove of transcripts he would want because they gave all the information necessary to do that. Documents showing invoices from Drs. Fishman, Dr. Negan, and Elevate Services, which is Ms. Mikowski's employer, and the total amount of money paid by the law firm, including the description of the services and the cases. Additionally, Progressive produced all the money it has paid over the past 3 years for every particular work under claim numbers to all these witnesses. We identified that Progressive paid Dr. Negan $900,000, Dr. Fishman $583,000, Ms. Mikowski $934,000, and that the law firm HMB paid another $600,000. We also produced 180 invoices from the experts to the law firm, which is what the judge wanted them to do. So we produced, and of course, under Rule 1.280, none of this stuff is required. All that's required under that rule is the money for the work in this case, the percentage of the work that you do for plaintiffs and defendants, to identify the cases that you testified, the percentage of hours or income as an expert, and they can get the dollar figure for the amount that the law firm or the insurer paid in the last 3 years. All of that was produced. The trial judge, and we talk about what the trial judge said. If your honors review what the trial judge said, he lamented on the state of discovery in Florida. He was kind of giving an editorial. And then we have to go by what the judge says. We can't assume what the judge means. What the judge says is what the judge means. And the judge said, I'm striking them because there's not enough financial bias information and because Mr. Byrd cannot get a group of depositions to create a library to give to other attorneys and to use in other cases. I'm not making that up. That's what the judge said. The reason, as to the Fabre issue that Mr. Byrd mentioned, the reason that we couldn't present more evidence is because the trial court abused its discretion in denying our motion for leave to have named the Fabre defendant. So that's a good reason for that. But even without that, here's the evidence that was presented at trial by the testimony that Mr. Byrd presented.
Why was it so late in the process that this was requested?
Fabre?
Yes.
We had trouble identifying who the actual sheriff's officers were at the intersection. They weren't, I believe, identified in the police report. But there's really no other excuse. We should have done it earlier. We certainly should have. But the question is it for a motion for leave to amend, is it futile? The answer is no. Did we abuse the process? No, this is our first motion for leave. And was it prejudicial? And to determine whether something is prejudicial, you look at whether the other side had notice. And in
this
this
would
case,
be an abuse of discretion you're asking us to find.
Correct. And because basically refusal to grant a leave to amend is an abuse of discretion unless you can show prejudice, an abuse of the privilege, or futility. In this case, the plaintiff knew as of January 22nd, 2022, that Hines alleged that there were officers who were negligent through her answers to interrogatories.
Let me ask, did you know the name of the officer or officers?
No.
Well, how is that not prejudicial to the plaintiff to say, okay, if you tell me the names of the officers that you want to classify as Fabre defendants, I could go subpoena them for trial and they could come in and testify. We absolutely had lights flashing and this lady drove by and she ignored us. I mean, to simply say, well, there was police officers with this sheriff's department and therefore that's an issue for the jury to decide. I mean, that strikes me as almost the height of prejudice, not being able to, not disclosing the witnesses' names.
So under Rule 768.81, you are allowed to include an unnamed non-party. It's kind of similar to using a phantom driver. If there's a hit and run and the driver leaves the scene, there is no requirement to specifically identify a name. And
these can be identifiable. The phantom driver may drive off a bridge and you never see him again. These are identifiable people that that clearly they can call as witnesses and say, hey, do you know that the defense is saying it's you share some of the fault here, and they could come in and testify, and I don't know,
Yeah,
it strikes me as very prejudicial, and there's no real reason why it wasn't brought to the attention of the trial court long ahead of whenever it was brought to by your trial counsel. So go ahead.
Understood. And the only response I would have is that under Rule 1.190, leave to amend shall be freely given. It's just a liberal policy in Florida, but I completely understand Your Honor's concerns. And I
But
really
isn't there
don't.
case law that the liberality decreases the closer you get to trial?
Correct. And we in our interrogatories I think a year and a half before trial, indicated that the officers directing traffic would also be liable. So this wasn't the day of trial. But nevertheless, Your
But
Honor,
nothing happened to identify them. It wasn't put on the front burner, so to speak. It's kind of
Understand.
a last minute, hey, we want to do this. And you're asking us to find that a trial judge abused discretion, that no other reasonable trial judge would have denied that under those circumstances.
Understand. And, it's very clear that the fiber issue is not going to carry the day, and that's fine. But the two main issues which are the two that I discussed in detail at length, were the striking the extras, which of course is the most important of the issues today. And also that accident report privilege information, which cannot come into trial, did come into trial and severely prejudiced defense. And I would point out, when something like that happens under the Special versus West-Spoken Medical, it is the burden of the opposing party to show no reasonable possibility that did not affect the verdict. And the plaintiff has not shown that at all.
Well, let me ask on the accident privilege. What is it that wouldn't your client have testified that, hey, I didn't see anybody, and I told him I didn't see anybody, and so
yes,
that part of the defense is that there was nobody. That was part of your attempted Fabre defense, is I didn't see anybody waving lights. And
they're separate issues, because what came in was communications between Hines and the investigating officer. That is what is prohibited under law. Hines told the officer, and this is what came in, that she did not see anyone behind her, and the officer then told her that there were people behind her. That is prohibited under 3.16.066 as a matter of statutory law. That is what's prohibited and cannot come in. For all these reasons, and especially as to the striking of the experts and the accident report privilege and the closing argument that I cited earlier today, we ask that this court reverse and remand for a new trial.
Okay. Thank you. Well argued, and court will be in recess until 11 a.m.
Thank you. Good morning.
Thank you, Your Honors.